Welcome, my little couch potatoes, to the comfiest courtroom on the internet. I'm your host, Llama, and it's time for dramatic testimony, overruled objections, and absolutely unqualified opinions. So grab your snuggiest blanket, some delicious snacks, and get ready to watch court with your internet besties. This is Couch Court with Llama.
Hello, friends. Happy Thursday.
Hi.
Oh, that reminds me. Oh, it's the 19th. I gotta write myself a note. A reminder to tell my niece happy 18th birthday.
You don't
Happy
have that
18th
wonderful part on your cell phone where you can schedule your text in advance?
No.
I love that.
What?
Yeah.
That's okay. She should be in school anyway, so I'll do my best.
My favorite thing. I'm like, send text to Paul at 12:30. Mind him to do this. And I'm like, schedule in advance. I'll have to remember to do it.
I love that.
Best thing.
I love that. Good morning, text packet. Good morning. Hope you're doing well. Pam, good morning as well. See, you've been singing. I love that. Well, you guys, we are here for more Laura Owens today. Oh boy. So Tuesday, where do we leave off? We left off with the defense. When the judge put down her order, she was like, listen, if you want the case dismissed, you're going to have to write the proper thing. And you're going to have to attach like a little certificate thing because what you did wasn't right and you know that. So let's do that this time around. And so that's what they did. They filed a motion to dismiss, and then they also filed like a judgment. And we learned basically what the statute in Arizona was about abortion coercion. And they said, well, she didn't include a medical provider who did it, so how could she even use this? And then they talked about how they believed that this was also unconstitutional on Greg because the words intimidate and coercion were not defined. So it was like, well, what does that mean? Where does the First Amendment, go in here? Because that sounds like it's
we should all be allowed to say, I don't want your bastard child.
Right.
Sorry.
So
not great, Greg.
It was certainly very interesting read they had there. It was rather technical, but some very good points that they were making. We learned a little bit about all of that. And so we knew that the next documents in line, the first one we're going to read today is Laura. Now, I haven't read any of these. I just read the titles. So both Buffy and I this time are on the same page. And it's her asking for more time because, to respond to that, because it was, illegal for once.
Mostly because she needs a dictionary.
Yes, that's true. That's true. Text packet says Arizona is changing that law if it passes. So quite an interesting change too. Yeah, I haven't had time to look that up, but I definitely want to because it was very interesting theoretical arguments going on there that I do think were important. So on both ends, right? What if you coerce somebody into keeping it or not keeping it? Anyway, it was very interesting. And so today is all about whether or not Laura gets more time to respond to it, because I can only imagine her response that excuse me, I don't understand any of it.
Because she needs a dictionary, a legal dictionary.
It's probably, excuse me, also why she doesn't initially have a lawyer, because they were probably thinking the same thing, like, girl, that's how that works. So that's what we'll be getting into today. Yes, please, if you can, text packet. I appreciate it. A new email, buddy. So we'll see. I feel like there's going to be snark. I don't know. Again, I haven't read them. So first we're going to read her motion to extend the time and then the defense's response to her wanting more time, which apparently is a little bit longer. It's about 22 pages, but there are lots of emails in there that I don't recognize. Do you have a bird?
No, I have a cat. That is really.
Was that your cat?
Yes.
Oh, she sounds weird.
I know. She sounds like she smokes a pack a day.
Yeah, I didn't know that was a cat.
She's like, you know,
Okay.
sounds like an old lady.
I was like, since when did you get a bird?
No, that's
okay.
my cat.
She's also like part zombie. Thank you.
Virginia Slims. What can I say?
I just want attention, but no attention at the same time. So we're going to get some new info today, and I'm very excited. And I hope there's lots of snark in this. And I feel like there will be because, Laura's representing herself pro se. And they're probably like, Like, that's the thing. When you represent yourself pro se, sometimes, like, they are a little bit more lenient to a degree. Because remember, it's a choice. If you want to take this to court and represent yourself, that's a choice. I wouldn't say they're as lenient in civil court as they are in criminal court. But that's because the standards in criminal are pretty serious. So,
yeah.
We all watch Daryl Brooks.
What he's the standard.
Oh man, do I love pro se defendants. I freaking love it. Because the audacity and the arrogance to be like, nope, I got this.
Well, on par, like she's not far off.
Right. I watched this one video on Reddit this morning. It was just a clip, so I'm not sure the whole context of the case, but it was like this young kid, probably like, I don't know, 18, 19 or something. And it has a murder charge of some, I don't understand. I don't know all the details, right? But he's standing there with his lawyer. We know he's facing at least one murder charge. And I don't understand why he wanted to tell this judge. He said, well, I shot all of them in the head. And his lawyer is like, how about you don't say anything? And he was like, how about you shut up and let me say what I want to say to the judge? Like, what? Sir, no. And so then he was like, well, I shot them all in the head and you're telling me only one's dead? Like,
well, at least there's only one murder charge.
For now. I mean, I don't know. But it was so weird. Like, sir, what are you trying to get across here? Anyway, it was very interesting.
Step on his foot, nudge him in the ribs, like
right. And he was just like, what? I love when you see, like, especially if you watch like Zoom courts and stuff, arrogant defendants just being like they think they know stuff and the way they treat their lawyers, and their lawyers are just like, all right. Like, I could never, if somebody was like that with me, I'd be like, okay, sound off. You go right ahead, sir. You just go right ahead. Go right ahead. Oh, you've seen it too?
I know, right?
Like, what was it? His name's Terrell Gibson. Okay, I didn't get any deets when I was looking at it this morning because I had to get ready like right after I saw it. So I'm gonna have to look more into Terrell Gibson. Sir, you did not make a good choice. Obviously. It's a cat. See, it's not a bird. Yeah, she's putting you on camera to show it. Look into the camera. And you want everybody to think how unhappy your life is. Okay.
Her name is Khaleesi.
Oh, of course, Mother of Dragons. That's probably why she sounds like that. Yeah, he looked really young, so I assumed late teens, early 20s, but no, it's a calico, so that makes sense. All right. Well, so talkative this morning. She never makes any noises. I've been friends with you for like 3 years, and I don't even know if I've ever heard that her make a noise ever. So that's interesting. She wants to be a star. I'm telling you, everybody wants to get on the train.
Now you know why her name is Khaleesi. I think she's in charge. Destroy everything.
Mother of Dragons, breaker of chains. Okay. So let's get into this first one. I made it big for everybody so they can all see. Excuse me. All right. So this again is Laura's motion to extend time to file a response to Greg's motion to dismiss partial motion for judgment on the pleading. So everything I just said, this is her response to what they had wrote about. So she says, Laura, pro se, respectfully requests an order granting Laura, pro se, why we need to repeat that twice, I don't know, an additional 30 days in which to respond to the defendant's motion to dismiss, partial motion for judgment on the pleadings filed on February 15th, 2022, which, given the court's exclusion of holidays and weekends in counting time to respond, would be due March 7th, 2022. Like, what else is she doing with her time that she was like, when did she file this? I'm sorry, I forgot to tell everyone when this was filed.
Isn't she caught up in the cactus stuff at the same time?
No, because that ends at the beginning of 2022. Okay. So she's done with.
I was like, well, maybe she's busy responding to other things. But
good question. No, they wrapped that up at the beginning of 2022. Sorry, I'm a little like mucusy today over this weather.
Well, it's bipolar. It's like
it is
up and down and up.
Well, and then you have your furnace up higher because it got cold. It is cold, and then it was down, and that's just don't like it. You send me a pic, I'll pass it to Buffy. Yes, I will. I imagine it's a cute picture of your cat. So they filed this on the 15th. She's filing this on February 25th, 10 days later, and it's due on the 7th. So that's not very many days. Well, most layers can fit it in there. For Laura, she's like, I don't know.
I'm kind of busy. I'm going on vacation.
Probably. Now, Laura is in the process of hiring an attorney. Oh, is that so? Needs time to brief themselves on the 40 plus docket entries. I don't know if you need that many days, Laura. I've read them all. Okay, they're pretty much the same thing over again.
I was about to say she just copy, cuts, and pastes from the last one.
Yeah, it's not. Whatever, girl. Laura has been timely with all filings to date, and this is the first request for an extension. Opposing counsel refuses to allow an extension beyond 7 days. They're bullies, guys. They're such bullies of Laura. Laura is attaching a good faith consultation certificate as pursuant to the rule. Wherefore,
what is a good faith consultation certificate? Is it like a IOU?
I think it's like a hey, we tried. I don't know. Hold on, let me find out.
The gold star. You tried.
Okay. Let's see that they've a certificate of good faith is a legal document often required in medical malpractice cases, certifying that a qualified expert has reviewed the case and confirmed a reasonable basis exists. Well, that doesn't count in this one. I don't know what that means. It doesn't matter. A good faith attempt to resolve the issue was made with the opposing party. Okay, so yes. Sorry, I was reading the completely wrong part.
Sorry, that's where my brain goes.
That's okay.
Like, what is this?
So she's saying, I tried to talk to them, and they said no. They said they wouldn't do it beyond a week, and that was rude. So here's this. We tried. Now, plaintiff respectfully moves the court to grant an extension until April 14th. You're asking for a whole nother month, babes? Are you serious? A month and a week.
She's busy, guys. She's busy.
Okay.
She's jumping horses.
See, I didn't think it was frequently used. I've hardly ever seen a certificate. Maybe they like really want them in pro se cases just for, appeals and stuff like, well, you said you talked about it. Within which to respond to Greg's motion, blah, blah, blah. A true and correct copy of the foregoing has been furnished via AZ Turbo Court on February 25th.
Is that like TurboTax?
I know, right? It's so stupid. No, I just think that's the court's like place where you file stuff.
I mean, it probably is. But I think my version sounds better. It's like you too can be your own lawyer. You can do your own taxes. You can be your own lawyer. Probably. I mean, that just using ChatGPT, which doesn't help.
Hi, Toadette. Hello. Hope you're doing well. Shoveling tons of soil. Ooh.
That sounds terrible.
Wait, Toadette. Are you burying a body? Don't tell us. Don't tell us, though.
Well,
Don't tell us.
ask. But you can shoot us.
What you really doing, Ms. Toadette?
You-
Where's Mr. Toadette?
Vague answers only. Vague answers only.
Right, she's busy not owning any businesses. I can't wait to see what her excuses are. All right, so down here, this is her good faith consultation certificate. The following issue exists between the parties. Applicable the law. Procedure requires a good faith consultation to resolve the issue before presenting it to court. Laura needs additional time to respond, and she tried to resolve it with them, but they were like, no. You can get a week.
She has a doctor's appointment scheduled that day.
Probably. She's probably pregnant with quintuplets or something. So that's that. She didn't whine as much as I thought she would have, to be quite honest with you. Your Honor, I just so much listening. Did you know my dad is so sick with
It's because she's a serious lawyer, Llama.
That's true. That's right.
You're making fun of her. She's serious.
She's so serious.
She's a serious attorney.
Oh gosh, she is the most unserious person too that I think I've ever come across. Like, oh gosh, this woman. All right, so this was filed 3 days after Laura's motion asking for more time, and this is the defense responding to whether or not she should get more time. So let's see what they have to say. I hope it's good. All right, so
come on, sassy Greg.
Come on, sassy Greg with 2 G's, which 2 G's means extra sassy. Excuse me.
I like it.
Oh, you're planting about 500 dahlia tubers instead of body. Okay, all right, sure.
I'm so glad you finished that sentence. Got about 500 dahlia. Okay, good. Because I was like, what in the mass? No, I'm just kidding.
Is that code for bodies, though? No, I'm just kidding.
I you know what? Vague answers.
Now, defendant Greg Gillespie, by and through his lawyers, hereby files his response objection to her wanting more time. And Greg provides as follows. All the reasons why she shouldn't be granted more time. What? She sucks. That's all, Your Honor. Here's my good faith consultation certificate. She sucks.
Send.
That would be great. Now, 1, under normal circumstances, routine requests for time extension should be liberally granted. That's true. Now, A, this is not a normal circumstance, nor a routine request, as Laura has a history of claiming legal representation when none exists.
Oh, the shade.
Yeah, she does do that, doesn't she? She sure does. B, these claims are part of a pattern of Laura's limited transparency, which are more fully detailed in Greg's counterclaim filed on January 4th, 2022. C, more specifically, as it relates to Laura's claims of having legal representation, Uncle Joe. On August 22, 2021, Laura sent Greg an email exchange allegedly between herself and California attorneys Joe Cotchett, shout out Uncle Joe, and Allison E. Cordova, discussing pursuing legal action against Greg. Ooh, got carried away. Laura attached a contingent fee agreement between herself and Cotchett, Petrie, and McCarthy LLP, dated August 23rd, 2021, Exhibit A, which we've seen. Upon information and belief, Allison E. Cordova is not employed at the firm and was not employed by the firm on August 22nd, 2021. So basically, they're being like, she's a liar who lies. Okay? And is making up stuff, allegedly. D, an email dated August 24th, 2021, indicated the firm does not represent Laura in this matter. Exhibit B. Defendant asserts that the 1-week courtesy extension offered is more than reasonable and enough time for an attorney to review 40 plus docket entries. and many of which are brief and not substantive in nature. No, they're not. Agreed. It doesn't take a lawyer to figure that out. We've read them. They're literally nothing, Laura.
Your lawyer has people that do that.
Right? Hi, Dan Montana. Hope you're well. She had a whiteboard in her room. I walked in and she had plausible. I love that. I hope you're doing well today.
I would say I love your daughter. She sounds like my kind of kid. Sounds like something mine would do.
Now, Laura, reason number 2, she shouldn't get a continuance. Laura has been, more time. Plaintiff has been aware of Greg's motion since February 3rd, 2022. So before they even filed it, she knew about it. Now, why did I say this? Well, on February 3rd, 2022, Laura and Greg had an early meeting. Remember, we read that. They submitted that document to the court to say, hey, we met-ish. And they talked about potential witnesses, all that stuff. And they specifically discussed that motion. Laura requested Greg clarify the motion, and the party spoke over a phone a second time later that day. Exhibit C. I just don't understand because I'm not a lawyer, so I'm going to need you to explain it to me so I can argue better against you. Okay, great. B, a draft of the motion was also forwarded to Laura as a courtesy on February 14th, 2022. Love that. With a request that she stipulate to dismiss the abortion coercion claim voluntarily prior to Greg filing the motion. They were giving her a way out, like just dismiss it. We're not gonna go hard, basically. And Laura, of course, declined to stipulate. She was like, no.
That tracks.
Yeah. Therefore, Greg's motion was ultimately filed on February 15th, 2022, pursuant to rules. Laura had 10 business days in addition to 5 calendar days to file a response. Therefore, Laura's response is due on March 7th, 2022. Come on, Laura. You have all this time writing allegedly fake emails and photoshopping things. I mean, come on. Maybe that's it. Maybe she could have just take somebody else's thing and copy and paste it. She's like, I couldn't find it anywhere to copy and paste. Well, what am I supposed to do? Use my brain?
Fiverr wouldn't get it back to her in time, so she needs an extension.
Well, it's probably against their policy too. She's probably like, yeah, nobody would do it, and I couldn't buy it from anybody. Now, on
TurboTax didn't have that document online, so now I have to research.
Oh my gosh, that's so funny. We in the community call her document changes arts and crafts. I mean, yeah. You know what else? Where else they have arts and crafts? Prison.
Oh, but
Now, on February 25th, 2022, Laura requests an extension from undersigned counsel until April 15th, 2022. Greg promptly responded by offering a week-long extension, making Laura's response due March 14th. The court is encouraged to read Laura's request and Greg's response, noting that undersigned counsel inadvertently calculated the response time to be due on March 10th, 2022 by failing to include the 5 calendar days permitted by Rule 6, Exhibit D. Now, Laura's request would have her filing a response on April 14th, 2022 to a motion she had knowledge of on February 3rd, 2022, and direct access to on February 14th, 2022, requesting what amounts to 2 to 2.5 months to file a response to defendant's motion to dismiss is entirely unreasonable. Laura, if you're going to try to play with the big boys, you're going to have to play. You're just going to have to play. Hi, Lainey. Hi, babes. Hope you're doing well. Nice to see you. Wherefore, Greg respectfully requests the following. A, that this court only grant Laura an additional 7 days until March 14th, 2022, to file her response to the motion. B, that this court grant such other and further relief as deemed appropriate. So anything else you want to give us would be great. Like, ruling on our motion to dismiss. That would be great. Okay, thanks. So there's that. Now we get to see some new exhibits somewhere. There we go. Now this is, oh, wait, no. Oh, this is a new one. I'm pretty sure. Yes, it is. I don't think we've seen this one yet. All right, so this was sent, this was from, I'm assuming, Laura, sent Sunday, August 22nd, 2021 to Greg. Urgent, but lowercase. Copy of conversation with Joe Cotchett and contract. Oh, wait, so it should have came together. But you know what? Whatever. Let's read it again anyway, shall we?
Hey, I'm here.
Why not? Let's refresh. Have a little refresher in our memories. It's been a while. Okay, so hi, Uncle Joe. First of all, I hope you had a great weekend and that the smoke didn't get as bad on the peninsula as you thought it would. I don't think we read this. I miss our dinners and hope you get out here soon. Although I've yet to find another house of prime rib. So lower your standards for now. What is with these people in the house?
I am so serious right now. Not sponsored.
Not sponsored. Oh, I'm not even in the house of prime rib. The one day I didn't put myself in there. Damn. Wasn't expecting him to pop up, but that's how the house of prime rib is.
Is that the only restaurant they have?
I think so. Those are the other two she talked about in Mike's case, the one where she was like, we go there every Wednesday, and he knows that, and he shouldn't have been within 7,000 feet of us. He's stalking us in public. Again, thank you so much for the enormous help you've put in this sad situation that I'm in. Here's where I'm at. Okay. After many emails, I heard from Greg this morning. He wanted to discuss things tomorrow at 7 p.m. I was surprised, but certainly wanted to give him the benefit of the doubt, since all I have wanted is for him to, say it as everybody together, keep his word.
Promises.
Promises.
You made promises. Did he though?
No.
Did he?
No. Since his initial message, I have sent more messages that I know he has read, and they have been left unresponded to. How unfair. As much as I want to give him more and more chances, I don't think he wants them. Really, girl. Really. Doesn't stop.
You think?
Doesn't stop.
That's what I got. That's what I got from the texts.
I think the best call is to pursue alternative service and try to get him twice. Once by posting on his house door, and the other by calling his company and finding a coworker to serve him, because that's logical. And no, it's crazy. It's crazy, Laura.
I would be so mad.
Over this, not appropriate. No.
I would be so mad if someone approached me and said, I need to serve him with papers. Can you just bring it to him?
Right. I think you're right that you would be better at making those phone calls than me. I texted you the coworkers who we could ask to serve. Also, would a lawyer even do this? I don't think so. I don't think they would try to contact some rando at somebody's company to get them to serve papers. That seems a little, I feel like that somehow isn't okay. But I don't know. Now, once that happens, we can file for the punitive damages like you recommended. I really do stand firm in staying under $100,000 in punitive damages, but I guess it also depends on the damages to the child. Although, wouldn't that also be covered in family court? I will think about what you said about trying to go for a settlement straight out of the box. Nobody says that. I don't want to play this nasty. Okay. Honestly, I just wish this never happened and that we could just be happy. Like he said we could be. Here's hoping he proves us wrong. I'm giving him one more change.
One more change.
Love. Laura.
XOXO. Gossip Girl.
Love Laura. Because that's appropriate to tell your potential lawyer. Love.
Right.
Yes. Okay. All right. That's what I thought, Tex. Yeah, no, absolutely. There's no way that would be all right. All right. Savage. I mean, that's how it is like here. I don't know if it's that same way in like all states. I would think so, but states are crazy about certain things. So I don't know. Oh, so you could serve Savage as long as I'm not the party in this claim. Oh, interesting. You essentially need a sworn document after service that says you did so. Well, how do you do that? You'd have to bring a witness with you, a notary or something. I don't know. It seems like a lawyer wouldn't do that, though. That's too much room for error and things to be thrown out in court. So, also, I don't think this is an appropriate conversation going on here anyway. So
you don't say love when you're texting your lawyer?
I know. Probably should. Oh, you are the witness. Well, that's not. Oh gosh.
Oh my gosh.
In California, hi Teresa. Anyone could be a process server at age 18. Well, look at that. But
what
they're not
a job.
But they're not in
sign
California.
up and just serve people's paperwork.
Ugh. I wouldn't want that job because nobody's happy to get the paperwork. It's not like a mailman or an Amazon driver where you're like, oh, I've been waiting all day. Thank you. I'm so excited. Have a great day. I don't think people are like that when they get served paper.
You just dress up as Amazon delivery guy. Everybody loves Amazon delivery guys.
That's true. That's true. All right. So this is allegedly from Joe Cotchett, Sunday, August 22, 2021. Oh, yeah, we read this one, but we'll read it again. Subject: sent on behalf of Joe Cotchett. Reply: Laura Owens pregnancy. Importance: high. I'm surprised it's not like the most. I don't know.
Wait, isn't high the most?
I don't know. I don't think that's enough, though. Sorry, guys. I'm a little like, today. I think it says, Laura, what's the update? I'm ready to get started on this the second you give me a go ahead! Exclamation point that they never use. As much as I want this guy to be exactly the man he's told you that he is. Gosh, every time I read this, I'm just like, there's no way this old ass lawyer man wrote any of these words. Okay.
My uncle will be like, damn, that sucks. That'd be it.
As much as I would love this guy to be exactly the man he's told you that he is, I'm not convinced that he is. I'm always here for you and the whole Owens family. Whenever you need me, and if you want me to go after this guy, I will make this case a top priority. Because I really feel for you right now. Allison sent me over, Allison, who does not work there during this time, sent me over the retention agreement and medical files. Every test result that came into our office matched what you had said. You have an easy open and shut case. This guy has nothing going his way here, and I think he could provide for a real landmark case regarding abortion coercion. And that's why she, is pro se for the first year of this because so many lawyers are jumping at the bit to take this very easy open and shut case. This may be very meaty, and we could make this a public interest story with the snap of a finger, a Thanos snap. However, in your interest, we could also just follow for judgment immediately so that you could start receiving money immediately. Remember, any man would feel like the luckiest man alive to have you by his side. You are polite, kind, and thoughtful as a little girl. And those qualities got even better as you got older.
That's
regardless
disturbing.
Of what happens, I am by your side. Uncle Joseph W. Cotchett.
Uncle with a smiley face. Ew!
Right.
This is icky. Icky vibes.
That's true. Tex says Uncle Joe is a witness for the prosecution for her criminal case, her felony criminal case.
I need justice for Uncle Joe.
There's no way. No way.
This is if he wrote this, wolf.
Yeah.
But if he didn't, then I'd be freaking mad because that makes you look real creepy.
Yeah. It's not great. It's not great. And then this one is from Allison, who does not work there at this time, but apparently is sending emails. She's not. That's why it's not real. Is Allison Cordova on the list as well? Text packet? Is she on the witness list? Oh, I need to pull up that witness list. I haven't because I was like, I don't know most of these people, but we do now.
Oh.
So maybe we'll have to pull that up or something and be like, oh, this is getting great.
You need a picture board, with all the match the faces to all the names. Just got to make a slideshow. This person.
Right.
I'm sure all the OGs know who all these people are, but
oh, you know what we should do? We should make a movie trailer. Man, Spider-Man brand new day dropped. Oh, we're gonna beat those 500 million views in a day. Forget about it. But a movie trailer for the trial.
Oh my gosh.
You don't believe she is? Okay. Well, there's always time. There's always time. They can change them at any point in time and add people at a certain point.
This would be like a horror story and trailer. I feel like it should be set to really creepy vibes.
Yes. We can make different ones. Well, it could be like a horror story where it starts off like one of those rom-coms. And then it gets very Kathy Bates and Misery very quickly.
Very Fatal Attraction.
Yes. Yes.
Oh my God.
All right. So she sent this. This is a couple days before even the other two messages on August 19, 2021 to Tony Stevens. I don't remember who Tony is. Subject, reply sent on behalf of Joe Cotchett. Reply, Laura Owens, pregnancy importance. Hi. Laura, please see below. Joe's secretary informed me that we had actually received the medical authorizations from you. Thank you. Everything you told us about. Nobody says this in these things. Okay. Everything you told us about pregnancy tests and ultrasounds aligned with the timing you provided us. Because if Laura is anything, it is not a liar. I can't even say it.
Woo!
I can't. It says her 14 felony charges she has right now. There were no past pregnancies on your record. Oh, really?
Ooh,
Really?
curious.
It's interesting. There should have been, apparently. And the 3 obstetricians you saw felt that pregnancy was very consistent with intercourse that took place between June 30th and July 1st.
Here's the thing. You're either pregnant or you're not.
Right. I mean, but I don't know. She thinks BJ's get you pregnant. I don't know.
It's like,
Oh, wait,
well, it's consistent with being pregnant. Well, she's either pregnant or she's not. It's not really a, well.
But you don't necessarily
wait,
need intercourse to get pregnant. There's turkey basters.
I mean, this isn't like the 1800s where you just have to wait 9 months and see if something pops out.
Right? Oh, could you imagine? Oh, I just realized we're not even on the vertical, whatever.
Oh, hey.
There we are. Oh, but I don't think that's the right one. There we go. Let's see. They have all said that the abortion pills will play a big role in your child's development. I would say so. They're supposed to kill it. They're supposed to stop that development.
I was whatever you had this morning because you are like giggles.
I know. I don't know. I'm delirious. It's hard to believe that this is real life and to take any of this seriously. Like,
no, it's funny.
How she was able to do all this with a straight face is beyond me. I'm just saying. It must feel like you have the weight of the world on you. But I have no doubt that the jury will sympathize with your situation. The next step is to fill out the retention agreement. Thank you, Best Allison, who doesn't work there anymore. And then they have the agreement, which just doesn't say anything. It's not important.
Wait a minute. Didn't we get to see all that in the other document?
This we did.
Here.
Yeah, I know. I don't know why some things are redacted. What are we doing? We have to block out LO, her initials on. I don't understand. Unless it maybe the little Lauren Owens. I don't know if they were blocked out for court or after somebody took them, they blocked them out. I don't know. So who knows? Who knows? Oh, yes, there is the other guy who doesn't want anything to do with any of this that we won't.
I don't blame him.
We won't talk about. I don't blame that guy either. I'm like, I don't want you to know where I am. Oh, okay. That's part of the agreement there still. Okay. All right. Exhibit B. All right. How about you? You wanna take a stab at these? I don't know where these are even from.
So it's from Double G, Gigi,
lawyer Greg,
to Patrice O'Malley, Urgent Gillespie. Okay, so from Greg to Patrice. We don't.
Oh, she must work at. I think she works at the. This is them trying to contact the law firm, Kotchett's law firm. I think is what this is here. Being like, yo, is this even representing her or what?
Okay.
I think.
Okay.
Oh, yes.
Because it's addressed to Joseph, even though it's to Patrice. Okay. Joseph, I'm confused as redacted. Laura shared your fee agreement, clearly confirming your firm's involvement. I accept that you are not representing her and wish she had counsel, but I have never had an opposing party share a fee agreement from a reputable law firm and then have the attorney deny representation. Perhaps I'm being overly cautious. I will point out that there are a number of documents being circulated that appear doctored. If your fee agreement and communications with Laura are in that vein, I assume your firm would want to be kept apprised.
Being like, yo, bro. Yo, bro, she's saying you said shit. This doesn't sound like lawyers. You might want to know about this.
It sounds like she's making arts and crafts with your paperwork. You might want to know.
Here's the reply.
Mr. Woodnick, I'm in receipt of your email, and we do not represent Laura in the above referenced matter. Sincerely, Joe Kotchett.
We do not underline. Do not.
Understand.
Oh, man. And this is Greg replying on Tuesday, August 24th to Joseph Kotchett again. There you go.
So who is Casey? That's his attorney.
That's Woodnick's partner.
Okay.
Yeah.
I knew I recognized the name, but
Mhm.
I just okay.
Yeah.
Joseph, I'm sorry to nudge, but the situation in Arizona is escalating with Ms. Owens. She is continuing to communicate with our client, notwithstanding specific instructions to the contrary, and has even started contacting his employer and family members.
Cuckoo.
In the middle.
Cuckoo.
Yeah, that's a choice. In the middle of the night, does she sleep?
No, but she needs 2 months to write a response.
I was like, oh my gosh. Like, in the middle of the night, she sent communication again, indicating that she would contact the police if Mr. Gillespie did not reconcile with her. I love how it's a question mark. Like, wait. Like, you need to call, like, rein in your client. Oh, wait.
Not your client, but
Not your client. You might want to fix this because she's saying she is your client. See attached email from your client entitled Criminal Charges Against Mr. Gillespie. If you are her attorney, I need you to confirm that immediately. If you are appearing pro hoc in Arizona, please also advise the name of your local sponsoring attorney. Please advise the name of your local sponsoring attorney is, okay, there was a word missing there, so that I can loop them into this. If your client is pregnant, we need to arrange the paternity test, as my client is happy to pay for the same. Some of the documents we have been receiving from your client appear to be altered / photoshopped. In all candor, I'm not sure if the letter she sent from you, Uncle Joe, is authentic. If it is, I would really like to talk to you today, as this is urgent.
Could you imagine getting this? What is happening?
I really
no
like
love from Greg.
Oh, I mean, aren't you supposed to send that from your attorney? Like attorney. Love Greg. Loves daddy.
All right. So this one is from Greg to, it looks like Joe again. So this time
he's gonna start like serial text emailing, because like hello. Okay, Mr. Cotchett, I represent Greg Gillespie in an Arizona paternity matter. Laura has indicated that you are her counsel and are part of a civil lawsuit involving our client. We do have a copy of a civil lawsuit she filed without counsel that in no way comports with Arizona's Title 25 and does not appear to have been prepared by your office. Are you representing her? With the level of rancor in the correspondence, I am being hyper careful not to communicate with a represented party. Miss Owens has forwarded private communication from you to her regarding this situation, and appears to be demanding either remuneration or reconciliation with our client. Please advise Miss Owens that she is not welcome to contact Mr. Gillespie going forward. The parties both have counsel, and we should be able to resolve these issues without escalation. My client has requested a non-invasive prenatal pregnancy test. He has offered to pay for the same and provided information on a qualified lab here in Maricopa County. Loves daddy.
I mean, yeah, like her sending, if you're having communication with your lawyer, don't send it to anyone else ever.
Right? Right? That's so dumb.
Also, I mean, even if he is representing Laura, like this is kind of how like lawyers communicate with one another. You know what I mean? Like, hey, your client's trying to get a hold of my client, make them stop, sort of thing.
Yeah.
Because it's pretty problematic. Like their lawyer, like if you're in a situation and they have a lawyer, and you have a lawyer, their lawyer is not allowed to contact you. They can only talk to your lawyer. And that's what he was trying to get away with.
Well, she's muddying the waters because she sounds like she has an attorney, but she's like doing everything pro se. And then it's like, well,
which is
she
it?
still shouldn't be contacting him anyway if she's pro se.
No, not at all. Not at all. All right. So this one is Exhibit C. I don't know. Let's see who this might be from. Link to Greg on. Oh, I think these are from Laura, I bet.
Is that why it's redacted?
I think so. Sent Thursday, February 3rd, 2022. And in the thing it said, hey, we talked before, we filed that motion with her. So I think this is Laura here. Subject, good faith consultation certificate. Probably because she's like, I don't know what that means. Mr. Woodnick, no hi. Come on, Laura. Be kind. Hi. You're so kind. Uncle Joe said you're still so kind, even as an adult. Where's the hi?
More so as an adult.
More so. That's right. I was looking back at my notes from the call and wanted clarification on the upcoming MTD's motions to dismiss. I know that you have to attach a good faith consultation certificate saying that you have, quote, tried in good faith to resolve the issue before the motion is filed. I'm not even sure what issues are that you are trying to get dismissed.
I can't read.
What? So we definitely haven't had a chance to discuss them yet because I don't understand. I'm very uncomfortable with you filing the good faith consultation certificate until we do. You mentioned adding an additional party, a constitutional issue, and a subject jurisdiction matter.
Subject matter jurisdiction?
Boom. Please let me
That's
know
Daryl Brooks.
if and when you have more information. She's like, I don't know what you're talking about.
That was a Daryl Brooks.
It was.
Like, circle back. Subject matter jurisdiction. Sorry. I think she has that backwards. Did she write that backwards? It's
right. I also
subject jurisdiction matter. Subject matter jurisdiction.
I'm not even sure what issues that you're trying to get dismissed because everything you told me, I didn't want to hear it. And no, I don't want to believe it. And so we didn't agree to anything until you made me believe it, which I never will. So, fine. Interstage left.
What that means.
All right.
Girl.
Exhibit D.
Oh, the D.
All right. From Greg to Laura. And
redacted means Laura.
The subject Gillespie and Owens. Laura, 1, you have claimed to be seeking representation from law firms in the past. Oh, wait, I forgot the date. What's the date on this? Oh, February 25th. This is when she filed.
Is this his response to that last
to
email? Like, I don't even know what you're trying to get dismissed. And he's like, here, let me number it out for you.
No. That was like right after their phone call. This email is right after she filed wanting more time. It's the same day as that, February 25th. Okay. So he's saying, 1, you have claimed to be seeking representation from law firms in the past and referenced attorneys who are no longer employed at these firms. You have been aware of the deadline to respond to our motion to dismiss since mid-February. We even discussed the same during the meet and confer days before the filing. 2, the caption of the motion is appropriate. It accurately and succinctly reflects the content. I am sorry you find it to be embarrassing and assure you that was not the intention. I don't even know if she's able to be embarrassed because she should be embarrassed AF right now. Like, well, all these years, but especially now. I don't think she's capable of being embarrassed. You are reminded that you initiated this action and listed the abortion coercion claim and even referenced criminal statutes in prior filings. It is in the public record because you made it public record.
Reed, you started this. Remember,
Right?
you started this.
Your reference to the PDA is just incorrect.
Oh my gosh.
The Pregnancy Discrimination Act only applies to discrimination in the workplace. It also only applies if you are pregnant. You have refused to confirm the same, notwithstanding something like 6 requests for that information.
Oh,
So sassy. Look at that.
I
love that.
know it. It's like,
Listen here, you
only
idiots.
applies if you're actually pregnant.
Notwithstanding the above, in good faith, we will agree to give you 7 additional days through March 10th to file a response. You are welcome to revise the draft stipulation to reflect this date extension and forward it to our attention for review. So, all right, so they must have been talking about, she has not submitted it yet, she's about to tell them that they are, and that's what they're saying. Because she does mention this in her filing, so this had to have come before. She was like, they only want to give me 7 days. And I need a lot more because my arguments are good. So I got to figure out something else.
It only applies if you are pregnant.
All right. So then Laura goes back and responds to Greg. Subject stipulation for extension of time to file a response. Blah, 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 blah. Hello. Oh, not even a hi. That's her serious. Hello. I am attaching a stipulation for extension of time, blah, 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 since I am retaining counsel who needs time to catch up on the 40 plus docket entries in this case.
What? It's not like 20 terabytes of data or something.
Right.
Right.
In
it's
addition,
like 40 dockets.
I ask you file a motion or request to redact a portion of the title of your what, bitch? Are you kidding me? Okay, sorry. I ask that you file a motion or request to redact a portion of the title of your motion to dismiss partial motion for judgment on the pleadings of plaintiff's abortion coercion claim, withdrawing of plaintiff's abortion coercion claim. I'm going to need you to take that. I don't like it. Please redact it. This is glaringly obvious on the public docket. And while I understand that the court has ruled on the motion to seal, it is a violation of HIPAA's privacy policy.
Ma'am, that is not how HIPAA works.
It's nothing to do with anything. She's so dumb. Unbelievable. It is a violation of HIPAA's privacy policy to put confidential health information on display like it is on the title.
Only if it's your doctor. This doesn't apply to anybody else. Oh my God. Okay.
She's so dumb. In addition, it could become a violation of the Pregnancy Discrimination Act if it remains. Okay. Good job, man, Greg. I must have lost his fucking mind when he read this. Like, what?
You know, this email was passed around the office. Y'all,
right?
Read this shit. Y'all gotta read this shit.
If you do not want to redact a portion of the title on your own terms, I will ask my new counsel to pursue it with the court. Okay, go ahead. Like,
I'm gonna tell.
Outside of deliberate efforts to embarrass me, there is no reason for Mr. Gillespie to want this non-public information about me to be public. I would appreciate your prompt response. Thank you.
Oh, for hell.
Laura.
Oh my
gosh, look at her signature. Laura, co-host of whatever the fuck her dumbass podcast
Stop
is.
it. No way.
Co-owner of whatever. And watch my TED Talk, the most watched new American TEDx talk of 2022. Shut up, Laura. You should be embarrassed of yourself. It's so embarrassing.
Oh my God.
Oh, she might now
Stop
be
it.
one of my
See?
favorite pro se people ever. Oh, she is. Girl.
So-
what?
Do you think Greg got this email and was like, all right, I gotta click the link. I need
Yeah.
to go watch this TED Talk to see what I'm up against here. Let's go see.
Yeah. It just shows you can have all the money in the world and still be a dumbass. Like she just sees, I don't even think she comprehends things that she reads. She's just like, oh, I like the title of this. I'm going to take that. Whether or not any of it applies to her or not, doesn't matter. She's like, I like the way it sounds. So I'm just going to use that. Okay, great. Thanks.
Oh.
It's crazy. Oh, that's all of those. That was so fun.
Oh, that was so fun.
Well, I guess we'll keep going because that didn't take near as long as I thought it was. So let me pull up some more because they're not done arguing about it, by the way.
Of course not. Nothing.
yeah.
No argument is fast with her.
No, it is not. Here, let me get rid of those two real quick while the other ones load. She is just... I can't believe she doesn't stop. How does she not stop? And you're going to be like, you're embarrassing me, girl.
No, baby, you're embarrassing yourself.
Right?
You
If you sue anybody, you should sue yourself. Like, for ruining your life by being so dumb. Oh my goodness.
That was crazy. The American with the discrimination against pregnant people or whatever it is. Like, stop it. Stop it.
Stop.
But it's so cute though. He's like, ma'am, that only applies if you're pregnant and only in the workplace.
You dumb. You better get that lawyer because you're gonna need it because you are not doing good.
Like, you are so dumb. You know that meme?
Yeah.
You are so dumb. I feel like we need it to like put on the screen after every dumb thing that we read. Like, you are so dumb.
Oh gosh, it's unbelievable.
I am gonna make a list of sound effects and inserts. I need
now that you found them today.
I feel like this is what now that I found them behind the scenes, I'm like, oh, I need this one and I need this one.
You are so dumb. Hi, Jill. Thank you so much. I'm glad you're enjoying our silliness with this because it's just, there is so much about it. There's just, oh my gosh, to wrap my head around any of this.
And we're so new to this. We have not been down this, or at least she's probably more than I am, but like, oh my gosh. Oh, so I am definitely learning.
These are, I will say, those emails were better than I could have dreamed of for today. That was,
I almost hate you for bringing me down this rabbit hole, but at the same time, I love you. I do, but like also,
dude, I'm never gonna have a day where I feel bad about myself ever. I'll be like, well, I'm not her. Thank God. Jeez.
But like having your stupidity on full display like this is, oh my God.
That's embarrassing. Now that's embarrassing. And that's why
I know that I'm not smart. Like, I know I don't know. Like, but I'm smart enough to know I don't know. You know what I mean?
Right. Exactly. You know, not that I think I do not have the ego enough to be like, oh, really? Well, I am going to send this to a lawyer and be like, oh, I know better about stuff than you, who went to law school and has a license to practice law and experience. Like, Are there some really dumb lawyers? Yes, there are. We've watched them in trial where I would be like,
Oh.
okay, I might be a better lawyer, but that is slim to
Did
none.
you watch the Corey Richards trial?
I did
Oh,
not.
it's the law firm of Dumb and Dumber. Yeah, they are something.
There are dumb lawyers out there, but just to be like this is just crazy. Normally you see this stuff in like Sov sits, and she's not even a Sov sit, which makes it all the better, honestly. Okay. So this is her motion to extend more time on March 11th. Okay. Her deadline was what, the 15th or 17th, with the week extension from that the defense was offering, but she is like, I need more time and expedited consideration requesting. You haven't got, basically like, sir, I really need this extended deadline because I didn't do any work hoping you'd say yes. And you haven't given me an answer for anything. So could you please check yes or no? Please. Thanks. Okay. We are couch court attorneys. You are right. That's right. We all went to the University of Llama. All right. Let's see what she's whining about now for 9 pages. Laura Owens, pro se, respectfully requests an order granting an additional 30 days in which to respond to Greg's motion to dismiss and all that fun stuff. As Laura's counsel filed a motion to withdraw with consent on March 10th, 2022, leaving Laura with 1 business day to hire new counsel and have them prepare a response in order to meet the deadline that Greg gave the plaintiff, Laura, on March 14th. So she hired a law firm.
Hey, I hate to interrupt you.
Sure.
Just got a call from my son's school. He's sick. I have to go pick him up.
Oh, that's okay. You go pick up little Mr. Buffy. I hope he's okay.
I'm sorry.
No, that's okay.
They wouldn't have called if he wasn't.
So. Well, that's true. But I meant like, I hope it's something serious.
Yeah.
You know.
All right. I'm sorry, y'all.
That's okay. You're fine. You're forgiven. You go be mom. Go be super mom. I'll have a good time over here. You can listen in the car.
Oh, I will. I'm so sorry, y'all.
Oh, that's okay. You just go that, and she wasn't the most watched new American TEDx talk in 2000. Jill, that's probably fake. I mean, she said it, so it must be true, Jill. Jeez. I'm just kidding. All right. So let's see, where were we? So she hires lawyers and then they withdraw. I don't know why. Do you know why in chat? I don't want to go looking it up. So if you know why she got rid of those lawyers, or they left on their own. But she is like, oh, they were supposed to do it and then they didn't. And now I don't have the time because I have to do it by myself. This is an impossible task. And Greg's counsel is unresponsive to Laura's efforts to come up with a resolution without the court's involvement. This is why Laura has requested expedited consideration. Laura also requests that a scheduling order is not created and that any discovery is put on hold until Laura's new counsel is hired, which Laura plans to do early next week of March 14th when this is due, but not sooner because it's not convenient for me. Like, girl, what? So you want everything to go on hold until you have a new, like, oh my, she's a Karen. Sorry, Karens, but yikes. Oh, that's true. Interesting. Now, on February 25th, Laura filed her wanting extension of time, and Laura requested 30 days beyond the court's deadline of March 7th to respond to Greg's partial second motion to dismiss, so Laura could retain new counsel. On February 28th, Greg filed a response and objection to me wanting more time, where Greg agreed to an extension until March 14th, conveniently when she's going to hire these new lawyers, but not to Laura's requested date of April 14th. There has been no ruling yet. How dare they? Excuse me. Now, oh, here we go. Here's lawyer details. On March 1st, Laura signed an agreement to hire attorney Zachary Mushkatel as counsel. And on March 4th, Mr. Mushkatel filed a notice of appearance. I feel like I might know why he's not around, but I don't know. On March 7th, Laura's now former counsel spoke to Greg's counsel and discussed whether Greg's counsel would grant additional time to Laura's now former counsel to catch up to the case and respond accordingly. And Greg's counsel readily agreed to this. Now, why would they agree to the lawyer and give him more time, but not her? It's not fair, because that's how it works. Now, on March 10th, Laura's now former counsel, Zachary Mushkatel, filed a motion to withdraw with client's consent. I'm going to go with it's because she didn't pay him. Anybody? Do we know why? I'm going to go with that's why. Or he finally read, all those 40 plus docket filings. And he was like, ooh, okay, this isn't great. Now, on March 10th, on March 11th at 8:21 a.m. specifically, Laura emailed Mr. Mushkatel's office to see if he could speak to Greg's counsel regarding giving Laura an extension to respond. As of March 11th at 4:45 p.m., Laura has not received a response from Laura's former counsel. How dare they not email me back after they're not my lawyer anymore to give me legal advice and do legal things for me? That's so rude. Laura has now lost 10 days that Laura otherwise would have had to find new counsel or put together a response to the motion to dismiss. Well, this sounds like a big old her problem. Hi, 80s. Hi, hope you're well today. Hello. In an email sent to Greg's counsel on March 11th at 11 a.m., Laura stated in part, quote, I am writing to request an extension to respond to your motions to hire new counsel and to ask that you create a scheduling order with him or her that is agreeable. Even if I were to somehow find and hire an attorney today, a task that is impossible to do, I'm sure, in Scottsdale, Arizona, where there's freaking lawyers everywhere, they would not be able to obtain Mr. Mushkatel's notes, arrange a fee agreement and contract with me, file a notice of appearance into the case, and speak to you to request an extension within the course of a few hours. I bet they could. Obviously, no counsel would consider filing in if they knew that the responses to your motion were due on 3/14. If you do not agree to this, look at her throwing threats around. If you do not agree to this, I will file a motion with the court, as I have clearly lost a considerable amount of time. I would prefer to handle this amongst ourselves, as I know that you would prefer to deal with counsel instead of me as a pro se litigant, and I am sure you would like that as soon as possible. I don't know. If I was Greg at this time, I'd be like, I don't know. I'm having fun with it just being you. Now, Laura has proof that Greg's counsel read the email 22 times between 11 a.m. and 5 p.m. Probably 22 times they read this email. I don't know what the email says yet. We'll read it, but I'm going to go with probably because it was unbelievably hilarious. The plaintiff resent the same email, adding that the plaintiff was aware of Greg's counsel opening the email and requesting a response no later than 4:30 p.m. so that if needed, a motion could be filed with the court before the end of the day on March 11th. Who does she think she is? Unbelievable. Laura is in possession of proof that Greg's counsel read the email 6 times between 3:39 p.m. and 5 p.m., well after the threatening time I gave them. Exhibit 2. As of 4:45 p.m., past my deadline, there has been no communication from Greg's counsel whatsoever. How dare they? Oh my gosh. She has all this time to be sending these emails. Girl, you got a motion you need to work on. Maybe spend your time doing that instead of tracking how many times people read emails, weirdo. The plaintiff is actively interviewing new counsel who, after filing a notice of appearance, will need time to brief themselves on the 40+ docket entries. There's so much to read and comprehend because she's having a hard time doing it. Laura understands that attorney representation for both parties is the most efficient way to argue the merits of the case. Greg's counsel has shown that they are unwilling to extend courtesy to Laura pro se, yet will if Laura hires counsel. Oh, what dicks. Laura plans to hire new counsel and have him or her file a notice of appearance in the case next week. She's crazy. She's just so crazy. When's the most diabolical, right? Ew, what? Ugh. People are crazy. People are crazy out there. Wherefore, Laura respectfully moves the court to grant an extension until April 14, 2022. You were going to give it to my other lawyer. Why won't you give it to me? Which is not how things work in court at all. Within which to respond to the defendant's motion, blah, 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 blah. And a true and correct copy of the foregoing has been furnished via Arizona Turbo Court on March 11, 2022. Love, Laura. Oh, here's her tracking those emails. She's crazy. Who does this? This is weird. Exhibit 1. We better get that email. Defendant's attorney has opened plaintiff's request for extension to respond to defendant's motion sent on March 11, 22 at 11 a.m. 22 times as of 5 p.m. He has not responded to Laura, which has necessitated the filing of this motion. She thinks the whole damn world revolves around her. So what if they look at it? They are not obligated to get right back to you. Jeez. Oh, she is so exhausting. Exhibit 2. Defendant's attorneys has opened my request for an extension to respond at 3:39 p.m. 6 times as of 5 p.m. yet has not responded back. How rude. All right. And here's her good faith consolation certificate filed along with this. The following issue exists between the parties, and the applicable Arizona rules of civil procedure requires good faith consolation to resolve the issue. Laura needs additional time. Blah, 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 blah. Plaintiff's new former counsel filed a motion to withdraw with consent on March 10th, leaving only one business day for Laura to hire new counsel and have them file a response. And she's requesting an extension until April 14th, and the defendant refuses to reply. How rude. So there's that one. Let me see how long the next one is. Is it a longer? No. You know what? It's only 5 pages. So we'll go ahead and wrap. We'll do one more, and then I'm going to save the rest for tomorrow. So the lovely Buffy doesn't have to miss out on too much today. Boom. Okay. So here is the defense's objection to Laura's second motion about wanting more time on 3/21. So this is after the due date. And this is them being like, no, probably. All right. Now, Greg Gillespie, by and through his lawyers, hereby files his responsive objection to Laura's second motion for more time. Greg incorporates his February 28th response objection to her first one to the extent applicable and provides as follows. 1. Currently pending before the court is Greg's motion to dismiss, partial motion for judgment, plaintiff's motion to extend time, on the pleadings, defendant's response objection to giving her more time, and now this one. I don't know why the court's not deciding on these things, to be quite honest with you. Like, what is kind of going on? These are pretty easy things to respond to, I would think, but okay. As iterated fully in Greg's initial response objection, Laura has been aware of the deadline to file her response since early February. A brief timeline is as follows, in case she forgot. And she loves putting dates and times on things. Well, only on her things, not other people. She doesn't like that. Now, on February 3rd, 2022, the parties held an early meeting, and Laura was informed that Greg intended to file his motion consistent with the requirements of the ARC. Laura then received a draft of the motion as courtesy on February 14th. That's right, they didn't have to do it. They were just nice, Laura. Greg's motion was filed on February 15th, pursuant to those rules, and Laura had 10 business days in addition to 5 calendar days to file a response. Thus, Laura's response was due on March 7th. On February 25th, Laura requested an extension from undersigned counsel until April 15th. And Greg responded by offering a week-long extension until March 14th. And then Laura filed her motion to extend more time, asking for an extension until April 14th, roughly 2.5 months after Laura became aware of the motion. On February 28th, Greg filed his response objection to the motion. On March 4th, Laura hired counsel. On March 10th, Laura's counsel withdrew. And on March 11th, Laura requested an additional extension of time to file her response and filed another motion to extend time. Laura again requested until April 14th to file her response and added the discovery be put on hold until plaintiff's new counsel is hired, which plaintiff plans to do early next week of March 14th. Notably, Laura inappropriately attempts to further delay her ARCP rule disclosure obligations in the second request for an extension, being like she doesn't want to hand stuff over to us, apparently. Oh, hi, guys. Oh, I'm sorry. I see new people stopped by. Hello, Mrs. BB Queen. Welcome back. So happy to see you again. And Boot Scoop. That's okay. You are forgiven. You're forgiven. But next time, please file a motion, okay, that you need time to an extension of time to show up to the stream. Okay, Boot Scoop. It's rude not to do that unless you're getting ready to hire a counsel. But you had a whole day warning. No, I'm just kidding. I'm just kidding. Hope you're well. Now, this is relevant because through investigative efforts by Greg, another matter in California involving Laura, and allegations of a fabricated pregnancy and abortion was discovered. I bet that's Mike Maricini. 7 months after this lawsuit was initiated, and only with effort by Greg, did this curiously similar matter come to light. To date, Laura has not provided any formal disclosure. Oh, so they've confronted her and been like, you need to turn stuff over. And she's like, no. Over the course of litigation, Laura's modus operandi has been to overwhelm the court with allegations and unsustainable legal theories. See Laura's motion to seal court records, which were hilarious. Laura's declaration of fraud, perjury, impersonation, extortion, and additional legal actions taken by defendant's counsel, also hilarious. And plaintiff's motion to modify service date, also hilarious, because then the judge ruled that she was absolutely wrong by a whole month. Laura previously indicated she was represented by attorney Joe Cotchett, who specifically disavowed involvement in this matter. See defendant's first response for the confirmation of that. Her recent attorney withdrew after only a matter of days, and now most recently, it is March 21st, and Laura has not retained new counsel as she represented the court she would be doing early in the week of March 14th. Laura. What was this little, hold on, where'd this footnote come from? Where are you, little number one? Oh, there it is up here. Her motion to extend time. The footnotes are sometimes fun. Plaintiff's motion indicates she can tell when counsel's emails are read. In addition to being inaccurate, it is woefully misleading and inappropriate. I love that. Hi, Liz. How you doing? Hope you're doing well today. Saw you around last night while you were just getting up and getting something to drink. You wonder if she's stalling on purpose. She would never do that. Miss BB Queen, get out of here. By the way, is it BB Queen because you like bees, or is it BB as in Big Brother Queen? Why BB Queen? Or is it BB Queen? I must know. I am obsessed with people's handles. So I need to know. All right. Anyway, she didn't get counsel like she said she was going to. So why should we take her word for anything ever? We shouldn't. Greg's motion to dismiss was filed February 15th, making Laura's response due March 7th. Although Greg agreed to a reasonable 1-week extension for Laura to file her response by March 14th, that time has now come and gone. Just like with everything Laura does. A lot of talk, no delivery. No delivery. Just like our babies. And imagine babies. Okay, let's just remind everyone, no real babies. Okay. Before somebody takes that comment I just said, I was like, you're a dick. And I'll be like, yeah, well, I can be, but they're not even real. As such, Greg respectfully submits that his motion to dismiss must be granted as Laura has failed to file a timely response. Any further delay would be patently unfair to Greg, who has already been forced to incur significant legal fees responding to allegations not supported by fact or law. Wherefore, Greg respectfully requests the following: that this court deny plaintiff's second motion to extend time, that this court grant their motion to dismiss, motion for judgment, and that this court grant such other and further relief as deemed appropriate, like lawyer fees and stuff. So there's that one. Okay. So that's all we're going to do today. But you guys, if you were like, what are we looking forward to tomorrow? Well, the first one up, plaintiff's response to defendant's motion to dismiss. So she finally comes with a motion for that. So can't wait to read that. I hope she wrote it. I hope she didn't get a lawyer. That's for sure. All right, let's see about BB's name here. Where'd she go? Where'd you go, BB? There we are. Okay. I sort of way too far. Oh, you like barbecues. Barbecue. See, I didn't even go there with the BBQ. Very clever. See, I love that. Barbecue Queen, but it was taken. Oh, early AOL days. Love that. I love that. See, it's always fun to learn how people came up with their, handles for things. Oh yeah, what does text packet mean? I don't know. Did I miss what text packets is? I don't know. Everybody can let me know what their handles mean, how they came up with it, because it's always fun. Because people will be like, how did you come up with Not a Drama Llama? And I was like, I don't know. It just popped up and there was nobody had it. I didn't even have a thing for llamas until I became Not a Drama Llama. So, and now people just literally call me Llama, like all day, every day, including my friends. So, and Elbow Feet will sometimes call me Llama if he's like listening. And then like afterwards we have a conversation. We'll be like, did I just call you that? And I'll be like, yeah, yeah, you did. Man, what a wild ride Laura is. Like, I can't even, and it gets crazier. I am surprised that the judge is allowing all of this tomfoolery. I mean, it's civil court. I get it. But at this point, like, what are we doing here? I don't understand why the judge is allowing this to continue on as long as it has. Because what they filed August of 2021 is when she files the civil suit. And we're now in March of 2022 in the story. And it's believed she fabricated a bunch of stuff, including impersonating a lawyer. Is it legal to impersonate a lawyer? Like, I know it's illegal to impersonate a cop and a doctor or a nurse. I'd assume it's illegal to impersonate a lawyer. I don't know. I have to look into that probably. Oh, yes. So, text it. Oh, TX means transmit. Oh, here, I thought you were from Texas the whole time. A packet is a bit of information that is transmitted over the internet. At the time, I was moving from one place to another quite a bit because of abuse, and it just fit. I like that, though, not the abuse part. The name part, how you got that to, going back and forth over the internet. Well, I love that. Definitely not. Oh, okay. So Texas is in your story. It was Texas you moved to. Well, look at that. I love the name more. I do know why Thirsty Kelly got her name. I'm pretty sure one of us gave it to you. And we never want you to change ever. Even when Mr. Thirsty Kelly P moves in with you. You'd be like, listen, I got a reputation to uphold, sir. It is illegal to impersonate a lawyer. I would think so. How does she not have charges for this? Your daughter came in and asked, had I made an account? I said, yes, but I didn't know what to put there. She took her phone and typed it and said, there you go. I always wondered, but then I was like, well, it kind of says. You didn't know. That's so funny. I love that. No, llama doesn't mean or have any origin now, but I've embraced it. And I have become the llama. Llamas aren't even my favorite animal. But I've embraced it, and now they are one of my faves. So I think it fits. I just didn't know until it was my time. But no, it was just one of those. I was like, oh, let's try this one. And nobody had it on YouTube, and nobody had it on other places. So if you see a Not a Drama Llama, it's probably me. But there's some people on, well, let me take that back. I don't have social media. So if you see these llama people on Twitter/X, I can assure you, because people have sent me some of those things and I've been like, no, I don't do social media. None of those people, they're imposters. So, not there. It is fun to say. I love it. So it just fits. It just fits. Well, you guys, thank you all for hanging out with us today. It's a little bit shorter, but tomorrow I think is going to be very, very good Friday for us. We're going to have a lot of fun. We get to finally read whatever Laura put together. Will she have a lawyer at this time? Will she not? I don't know. Because I said I have not read. after this point, I haven't actually like read any of these documents, like the earlier ones, which proved to be great today. And then we're going to be getting into some Zoom court hearings. Now, I did read some of the comments left under our videos, because we do that and we love your guys' comments. They're so great. And also to the replay crew who aren't here when we're live, we do appreciate you guys as well and all your comments afterwards. And we're so happy you found us. We love that. Some of you said, though, that the Gillespie hearings are kind of boring. Maybe they are. Maybe they aren't. I don't know. We watch a lot of trials, so I don't know. Boring is subjective. All right. Listen, I covered like a 6-week trial that was the most boring trial ever in January and February. So it can't be worse. It cannot be worse than New Jersey versus Paul Canero. It can't be worse. Can it? No. So we'll be watching some of those tomorrow too, probably. But so that's all I got for you. Tonight, we're continuing, Terry, True Crime, and I are continuing our Robert Hansen coverage, part 7, where we're finishing up covering the 1970s. If you think you know the Robert Hansen story, I assure you, you probably do not. Everybody knows about his, he's a serial killer. He killed 17 women, but the years leading up to that are really infuriating because he could have been stopped and should have been stopped numerous times. So check that out while we're on break. I'll be back with part 7 for that. We will be back tomorrow with more Laura Owens coverage. And what time do I start? 11 a.m. Eastern. That's what time I start. So I appreciate you all being here. It's just not TV court exciting. Well, I'm sure we can make them exciting though, right? Does anybody have a bingo card? Are they bingo card worthy? I don't know. So, so I'll be here tomorrow at 11 a.m. with the lovely Buffy again. Hopefully little Mr. Buffy isn't too sick, but I'll be here regardless whether she can or not. But thank you all for being here today. Be safe, and until next time, you know how I say it. Go forth and be amazing. All right. Bye, everybody. Have a great day. Bye.